This is the current federal tax developments for the week of May the 11th, 2026. Current federal tax developments are brought to you by your state society of CPAs. And we're going to start looking at developments for this week, see what's happening and what's affecting your practice, your clients out there. The agenda is going to cover a wide range of updates. They're going to span from syndicated conservation easements and unitary business doctrines to limitations on jurisdictional time bars for refund claims, and the boundary of executive authority on tariffs. We're going to begin looking at a recent tax court memorandum decision dealing with the area of syndicated conservation easements, a topic we keep coming back to because these just keep coming up. The IRS continues to litigate these cases, and more interestingly, the partnerships continue to litigate them, and it's still not going well for the partnerships. This one is the decision in Kimberly Road, Fulton 25 LLC versus Commissioner, and a related case of South Fulton Parkway 58 LLC versus Commissioner. These cases were consolidated. The opinion is Tax Court Memorandum Decision 2026-36. It came out on May the 4th. Now, this was a TEFRA exam, and these cases are prime examples of this ongoing litigation we've had, and with basically the same results under Section 170H. And while the taxpayer in these cases actually succeeded in defending the procedural validity and statutory conservation purposes of easements, which, by the way, they tend to do. The IRS will attack those. They usually lose. But where everything falls apart is their deductions get totally disallowed by the aggressive, well, not totally, but close enough that we might as well call it totally, by the aggressive valuation methodologies and speculative highest and best use that they used in coming up with their appraisals, which they use as a basis for their value of the donated conservation easement. So let's take a look at the facts. The taxpayers are two Georgia limited liability companies treated as partnerships for federal tax purposes. They're formed by a real estate investor, Jeffrey Grant, and a private equity manager, Daniel Cabrana. The properties at issue were two vacant parcels in Atlanta area acquired at very deep discounts. The 25.4-acre Kimberly Road property was acquired post-foreclosure for just $500,000, and 130-acre South Fulton property was acquired as part of a multi-state bundle for even less, $350,000, right, in that case. Now, the syndicators raised capital via a private placement memorandum, a PPM, that projected a massive 145% targeted return, driven almost entirely by the anticipated tax benefits rather than any economic fundamentals that we had here in the, what the partnership was going to do. Rather, the tax people, the federal government, will simply give you the return. In December 2017, both partnerships granted conservation easements to the Southern Conservation Trust, SCT, which was a qualified IRC 501c3 charitable organization. For the 2017 tax year, the partnerships claimed non-cash charitable contribution deductions exceeding $25 million. Remember, totally they put in $850,000, right? And specifically, $9,866,000 donation was claimed for the Kimberly Road conservation easement, and $15,871,000 was claimed for South Fulton. So how did this magic happen that they got these killer deals on these properties and then were able to, shortly thereafter, contribute these conservation easements that are worth this fortune? Well, these rules tend to be based on an assumption, or not these rules, these cases, and the logic, that the sellers were idiots. And every other person in America was an idiot because nobody saw what this partnership saw. And then finally, just to prove everybody's an idiot, instead of developing this and doing the things that would make these things super valuable cash cows, these guys just give it away. So everyone's an idiot. Great. Well, court doesn't quite buy everybody's an idiot, but there may be a few that there are some concerns about in this realm. Okay, in this case, we're going to take a look at economic substance and the IRS's claim that they failed on various procedural issues. The IRS audited the return. They issued a notice of final partnership administrative adjustment, the old TEFRA notice, disallow the deductions in full and assess the 40% gross valuation misstatement penalty under Internal Revenue Code Section 6662H, that friendly thing we have seen multiple times in these cases and has become a huge problem. Now, the commissioner's initial litigation strategy attacked the economic substance of the partnerships, citing historic Boardwalk Hall versus Commissioner, which was a 2012 Third Circuit decision, 694 F. 3rd 425. The IRS argued the partnerships lacked a valid economic purpose, and the pursuit of tax benefits negated entirely the donative intent required under 170. IRS loves this argument. Tax court, not so much. Judge Holmes rejected this idea. The court distinguished historic Boardwalk, noting the deductions for donating property to nonprofits are specifically authorized by the code in this case and do not require a separate investment or business purpose. Congress can provide that we'll give you a break for doing X, and you aren't required to have a business purpose for doing it. Right? Or even basically have charitable intent in this regard. So relying on the 1989 case of Hernandez versus Commissioner and the 1986 case of the United States versus American Bar Endowment versus United States, basically, I should say versus United States, to be repetitive, both of which are U.S. Supreme Court cases, the court held that the subjective donative intent is largely immaterial unless there is a direct quid pro quo from the donee. That is, we got something. Because the tax benefits flowed from Congress, not the donee, right? The benefit here, they did get something for doing it, but that benefit came from Congress saying you'll get it. That case, that's allowed. If the charity essentially effectively gives it to you, then that's a different thing, right? And so because of that, the benefits were legally incidental to the objective donation. You get this, that's fine. Procedurally, the IRS tried to disqualify the appraisals under Trades Regulation 1.170 Cap A-13 C2IA. Regulation citations are always great fun. Arguing the primary appraiser acted as an advocate. So they're attacking the qualified appraiser and qualified appraisal. Now, the court rejected this, finding the appraiser maintained sufficient objectivity. Okay. IRS likes to attack this one too, saying, well, I know we got no direct evidence of this, but, you'd have to be an idiot not to, to believe that this was an objective appraisal when everybody knew this is being marketed, etc. Yeah, no, the courts don't tend to buy that. In essence, you better have some objective evidence that the appraiser essentially was told, come in at this number or you're not getting paid. That'd be kind of bad. We'll phrase it that way. Finally, the IRS attacked the South Fulton return because a co-appraiser failed to sign the Form 8283. The court applied the doctrine of substantial compliance, holding the defect was cured because the appraiser signed the actual appraisal and a certification containing identical language, therefore providing the commissioner with sufficient information to evaluate the contribution. We're not going to get into those minor technicalities. Now, remember, part of this is really important because a lot of the not conservation easement, but a lot of the rules involving appraisals are governed by regulatory language. We know that we get strict on charitable contributions, very strict, but that's when statutory language is involved, right? We are not going to, no harm, no foul on a statutory misstep, like failing to get a current written acknowledgement. Failing to get it currently is the big one. But we are going to allow it easier here, and the courts do, because they've got one thing they're going to hammer, right? But the IRS still had another way to try to get it, which usually doesn't win and didn't. Because they went after the conservation purpose arguments. Under 170H1, a qualified conservation contribution must be made exclusively for conservation. Now, the taxpayer's argument that their easements met the two statutory purposes: protecting a relatively natural habitat under 170H4A and preserving open space under 170H4A. Now, the tax court relied on the 11th Circuit's precedent in Champions Retreat Golf Founders LLC versus Commissioner from 2020, taking a flexible approach to finding a significant habitat. The properties protected rare and threatened species, including the tricolored bat, brown-headed nuthatch, and downy arrowhead shrub. The IRS argued the Kimberly Road property was too small and degraded, but the court clarified that the code does not require minimum size, nor does it require that protected species inhabit the entire property. The open space requirement was satisfied pursuant to the Georgia State Wildlife Action Plan, which is abbreviated as SWAP, you'll see in the case. Furthermore, the court held that the reserved rights like logging and hunting do not destroy the conservation purpose. In fact, hunting acts as a useful monitoring mechanism against trespassers who would damage that purpose. Okay, well, we've gotten through the good news for the taxpayers now. Been all good news so far. Now we get to the bad news, right? The valuation conundrum, highest and best use. So as I said, they've survived the procedural and statutory hurdles. Now we're going to go into complete collapse on valuation, which is where the tax court has been hammering these things. Pursuant to Treasury Regulation 1.170A-143I and 2 and double I, when comparable sales of easements are unavailable, the before and after method must be used, which relies heavily on determining what is the property's highest and best use, and you're going to determine that both with and without the easement being in place. Now, the taxpayer's appraiser utilized highly speculative highest and best use assumptions. For instance, proposing a 600-unit assisted living facility, not Liberty, living, situated on a 50-foot cliff for the Kimberly Road property. To justify these values, he pulled comparable sales of developed parcels from wealthy areas up to 50 miles away. You can see a little problem here with comparables. And cliffs are kind of interesting place to put one of these, but okay. In contrast, essentially, the IRS appraiser, Charles Brigden, utilized comparable sales of vacant raw land located within a close radius of the subject property. And the court went with the IRS, firmly establishing that a legally permissible use under zoning laws does not dictate highest and best use if it lacks economic feasibility and market demand. This is the appraiser reacting to prior cases where people have just assumed away zoning problems. Well, it's not just enough to be legal. As the court notes, yeah, legal really helps, but it's also got to be economically feasible, and there has to be enough market demand to have it make sense. The court criticized the taxpayer's appraiser for crossing market demographics, ruling that fair market value must turn on a realistic and objective potential use, not just a possible. And right, and yes, I know we've had disallowances before because it wasn't even legal to do it. But the mere fact it's legal is also not enough. You got to show somebody would do it. It might be legal to build in the middle of the desert here in Arizona, the world's tallest skyscraper for, office use, for urban area office use. That doesn't mean it's practical or anybody's going to do it. Right? Same difference there. Okay. So now let's go to penalties. And our friend, the gross valuation misstatement penalty, comes home to roost again. Because the tax court adopted the IRS's valuation, the taxpayer's claim deduction of $26 million were drastically slashed. The court allowed a before and after deduction over $430,000 for the Kimberly Road and $610,000 for South Fulton properties. Yeah, that's down a bit. Mm-hmm. The massive shortfall triggered the 6262H exam. Remember, this is a 40% strict liability penalty if the value claimed in return is 200% or more of the correct value. It's critical to remind clients that Congress eliminated any reasonable cause defense for a gross misvaluation misstatement charitable contribution property under 6664C3. While you can do it for, basically a substantial valuation misstatement, that is, from 150 up to 200%. Once you clear 200%, that penalty's coming the minute the mechanics work to say that, the court found that the true value was less than half of the claimed value. And I've had a few appraisers ask, well, how do you set that value? I said the judge does. The judge is in control of this. Right? If you're going now, you can obviously try to go to Court of Appeals and claim that the courts, basically clearly didn't properly apply the valuation rules to the facts. That's an uphill climb, though. I mean, it's one of those things that has a lot of discretion at the trial courts level. So, yeah, the judge is going to call it, and the judges don't like these. That makes it easy. Okay. So the penalties are mandatory. As Judge Holmes stated, this is a math question. It's a math question. that we must find the commissioner got right. Once Judge Holmes came down with his values, the 40% penalty was locked in stone. There was no option, right? And unless you can somehow, through the appellate process, get to a point where you go back to deciding what the property is really worth and get a higher worth number, that penalty is not going anywhere. Now, we do have, again, as always, we started adding in these visual, infographics, right? And even when the taxpayer flawlessly navigates the complex statutory and regulatory framework of 170H, which is what's talked about there, basically it works fine, right? There's legitimate conservation purpose and they fulfilled all the procedural appraiser rules. Deduction is going to fail if it relies on speculative highest and best use models. You need to get that through to any client who's thinking about doing something like this. Well, syndicated conservation easements have been knocked down pretty much by changes in the statute that essentially you can't, if you have this multiplier in a current one, it's just disallowed automatically. But we're seeing some people try, we've seen a couple of cases where they tried to do it, not in a syndicated easement, but somebody just had a property and tried to do kind of, roll your own version. That doesn't work any better. When advising clients on real estate donations, you have to scrutinize the appraiser's comparable sales methodology. This is one where it's just simply, look, you can say, well, I'm not an appraiser. That's true. You probably aren't. I'm not. But really, neither is the judge. And it's just not realistic that if I'm looking for the highest and best use of a property, sitting in, a certain area of Phoenix, let's say, right, which has, it's a lot easier to develop here. Let's say do things like that. If I go look at, what would be highest and best use in other locations, that's not going to be the same. I really don't have the same options, freedom. There's reasons why we do things. You're going to just have different highest and best uses depending upon where the property is. And what happened in many cases where things weren't comparable at all. And that's what killed this one. And remember the 40% gross valuation misstatement penalties, as I told a group of appraisers I spoke to about a week ago, you really always have to, advise clients of this problem. If it turns out my value for a charitable contribution property is found by the court to be more than twice the actual value, there's going to be a 40% penalty on the tax you saved. You'll pay back the tax and 40%. So one thing you got to realize, and like I said, I think that's really helpful for appraisers to know, just to deal with the fly-by-night appraisers is, somebody might give you a value that's way higher than I'm giving you, but you better hope they're right, or at least not more than 2 times wrong. Because if they are, you're not only paying back the tax savings, you're paying a whole heap of money on top of that. Now, so to our next major development. This is the case of Garcia-Rojas versus the Franchise Tax Board. Case A172054 from the California Court of Appeals, the First Appellate Division, Division 3, First Appellate District, I should say, Division 3, issued on May the 1st of 2026. And this is an interesting decision because it goes against what is a decision of the Office of Tax Appeals that the Franchise Tax Board had been relying heavily upon, right? And what this looks at is the California's Unitary Business Doctrine, something that was glanced over in the case the Franchise Tax Board loves to go to. Specifically, the court evaluated whether the Franchise Tax Board could legally classify a non-resident independent contractor operating strictly as a sole proprietorship as a unitary business subject to California income apportionment under California Code of Regulations, Title 18, Section 17951-4C. Do we need more than one business to be a unitary business? Because these regs apply only to unitary businesses. What's the factual groundwork of this case? Well, this taxpayer, Dr. Garcia-Rojas, is a radiologist who resided and worked exclusively in Texas. In 2017, he entered into an independent contractor agreement with Stat Radiology Medical Corporation, StatRad, a California-based medical corporation. StatRad routed imaging studies to him from medical facilities in California and from across the country, which he analyzed from his Texas home using StatRad's proprietary software. StatRad heavily facilitated his practice, paid his licensing fee in 28 states, including his home state of Texas. I should say, excluding that. He had to be licensed in Texas. They paid for the other states he would now need to be licensed in order to, basically do the remote work of essentially reading the x-rays, right, from the remote location. Secured his hospital privileges, necessary in these cases. Provided the necessary hardware, a California mailing address, software training, and importantly, California malpractice insurance. He was highly compensated, earning roughly $305,000 and $410,000 annually in that range from 2018 to 2020. Federal tax purposes, he appropriately reports income strictly on IRS Schedule C as a sole proprietorship. Remember, his income wasn't all coming essentially from the state of California. He was looking at images from other states, but California now is interested in it. Right? We have this. The Franchise Tax Board's assessment. Where did we get here? In July 2019, the Franchise Tax Board aggressively pursued Dr. Garcia-Rojas, demanding he file California returns. He complied for 2018, 2019, and 2020, paid the assessed amounts, then immediately sued for a refund. This is key here. By paying the tax and suing for the refund, California's system is similar to the feds. If you don't want to pay the tax, you have to go through the OTA, right? Protest there. Dr. Rojas paid the tax and got into the regular court system by suing for a refund. At the trial court level, though, the Franchise Tax Board won a motion for summary judgment. So Dr. Rojas lost at the trial court level. The trial court agreed with the Franchise Tax Board theory that, as a matter of law, Garcia-Rojas operated a sole proprietorship that carried on a unitary business subject to taxation under California Code of Regulations, Title 18, Section 17951-4C. Lower court's reasoning was that conduct across state lines was not separate and distinct enough to qualify as a separate business, particularly because he used identical research from StatRad, regardless of where the imaging report originated. Now let's talk about the statutory definition of a unitary business, which is where the appellate court's going to break from the trial court. What's the statutory framework of it? California Revenue and Taxation Code, Section 17041I1B, and Section 17951 permit the state to tax a non-resident's gross income derived from California sources. When income is derived from sources both inside and outside the state, Revenue Taxation Code Section 17954 requires allocation and apportionment. To implement this, the Franchise Tax Board promulgated Regulation 17951-4C, which forces a non-resident to use the UDIPTA, right, apportionment rules if their sole proprietorship carries on a unitary business within and without the state. Those are the effectively standardized apportionment options. The fatal flaw in the argument was the legal definition of a unitary business. The Court of Appeals pointed to established California Supreme Court appellate precedent, such as Bunzl Distribution USA versus Franchise Tax Board in 2018, and General Motors Corporation versus Franchise Tax Board from 2006, which defines a unitary business as two or more business entities that are commonly owned and integrate in a way that transfers value among the affiliated entities. Where are the two or more commonly controlled entities here? That's going to be the Court of Appeals question. Court of Appeal then dismantled that doctrine to a single individual, based on essentially what I just asked. The court emphasized that Dr. Garcia-Rojas was engaging only in one business activity. Historically, the unitary business doctrine has only been applied to multinational enterprises or parent companies with multiple subsidiaries, never to a single person engaging in a solitary activity. Now, the Franchise Tax Board, as I mentioned, tried to rely on an Office of Tax Appeals decision, the appeal of Bentley, which came down May 30, 2019. It is the OTA case number 18032-402, which previously held an Arizona-based screenwriter operating a unitary business. The appellate court forcefully discarded this, saying that was garbage, noting the OTA decisions are not binding on them, right? And criticizing the Bentley decision for erroneously focusing on functional integration while ignoring the foundational requirement that we need two business entities, right? We need at least two, and we don't have them, right? So essentially, what at least this panel is telling us is, had Bindley paid the tax and sued for the refund and come up in front of them, he'd have gotten his money back. Okay, well, choice of venue is somewhat important. We can talk about that. The court also dismissed the FTB's citation of California Code of Regulations, Title 18, Section 25120B, as the plain language regulation explicitly requires two or more businesses of a single taxpayer. Again, where are the two? Where are two businesses? Okay, this one might not require two entities, but it needs two businesses. He's a radiologist reading, the stuff coming in. That's a single business, not two. So the conclusion, ultimately, the appellate court reversed summary judgment, ruling that the Franchise Tax Board failed to prove that Dr. Garcia-Rojas operated a unitary business as a matter of law. The current state of the law, therefore, is that a sole proprietorship serving clients cross-border through a single overarching business activity cannot be forced into the complex unitary apportionment under Regulation 17951-4C, right? At least, and that's this court's ruling. But there is a really important caveat at the very end of the court's decision. The court explicitly stated, we express no opinion as whether the board can tax Garcia-Rojas under a different legal theory. Now, that's an interesting comment for the court to put in. Is it just stating the obvious? I mean, the court doesn't rule on what's not before it. Is it saying, we all have the way you should have argued this, you just did it wrong? So you got to consider that this did not say that Dr. Garcia-Rojas is not taxable on this income. It says he's not going to have to pay the tax on the income. He's going to get a refund because, they argued law that doesn't support it. But there are other ways the board could come back. Who knows how they'll do it? Who knows the option? But knowing the Franchise Tax Board, they'll definitely be working on that sentence. So the Franchise Tax Board clearly might still attempt to capture this income by auditing similar taxpayers under alternative legal theory, such as California's market-based sourcing rules for sales of services. You got to remain somewhat vigilant when advising non-resident independent contractors with California-based clients that they have an exposure to California. And California goes after people nationwide about this. So even if you're sitting here saying, well, I don't need to worry about this, I'm here in North Carolina, this doesn't matter to us. Yeah, it probably does. With remote work, remote issues, and your client is a service provider that does not have to perform the services on site, like, let's say, a CPA firm, doing tax work. Yeah, this is still open as a potential way the Franchise Tax Board will try to come after people. And I don't expect them to give up based on one Court of Appeals ruling. I expect they're going to, will they take this case to the Supreme Court? That's a risky move because California Supreme Court says the same thing. Yep, you need more than one business. That kind of shuts them down, even under the OTA. So, yeah, we'll have to see. Also, we're going to see if the OTA takes any consideration of this opinion, or if the OTA comes up with a different theory about why unitary business can be one business. Okay. So again, we have our nice little infographics as here, right? So again, we have our dispute on the left and the court ruling on the right. Right. Again, you can get this infographic. It's in the slides. If you go to our website, conversationdevelopments.com, go to the basically the updates, the audio and video updates. It's there on the link on the entry for this show, this particular program, show, whatever you want to call it. You can go get these, and they're kind of useful to summarize this, right? It basically talks about the case. They challenged overall $1.1 million over the years in question in earnings. And they, applied the unitary label would apply automatically. The court made it very simple. Despite the trial court having no problem with a sole proprietor coming out of unitary business rules definition, the Court of Appeal has a huge problem with it. Again, stating you have to have two or more entities. You don't have that here. They cannot use the regulations they use. Period. That's the option. Okay. Next up, what happens in this case is we are going to be look to corporate tax administration issues, and this is IRS Revenue Procedure 2026-21, right? Which is reinstating the significant issue letter ruling program, right? Well, what is that? Well, it deals with if you're handling complex corporate reorganizations, spinoffs, and liquidations, you're going to probably be looking to secure, in many cases, a private letter ruling from the IRS because that will manage tax risk. And again, the downside of discovering later on this didn't work could be very nasty. The new revenue procedure marks a highly anticipated shift in IRS policy by formally reinstating the significant issue letter ruling program as opposed to only ruling on everything as an integrated package. So, IRS has bounced back and forth on this over time. So let's talk about the program's purpose and why it's being reinstated. Right? Historically, the IRS has oscillated in its willingness to rule on only part of an integrated corporate transaction. These things tend to have a lot of steps. Right? Under previous guidance, Revenue Procedure 2024-1 and Revenue Procedure 2024-3, the IRS had essentially ended the practice of issuing significant issue rulings, maintaining a general policy that would not issue a letter ruling on only part of an integrated transaction. Revenue Procedure 2026-21 reverses course and directly modifies, 2026-1 and 2026-3 to reinstate the program. IRS noted that this change was driven by numerous informal comments from practitioners complaining about the time required to process broad, transaction-wide letter ruling requests when the only real concern was one piece of it, one issue. The goal here is to use IRS resources more efficiently and increase the timeliness of rulings by allowing taxpayers to seek targeted guidance without analyzing every single facet of a complex transaction. This program is jurisdictionally limited, note. The issues must fall solely under the jurisdiction of the Associate Chief Counsel Corporate for any of this to count. So keep that in mind. So benefits from this program? This program carves out a permanent exception to general no-rule policy for a specific type of corporate transactions. It specifically applies to corporate liquidations under Section 332, transfer to controlled corporations under Section 351, corporate divisions and spinoffs under Section 355, corporate organizations under Section 368, and certain stock-for-stock exchanges under Internal Revenue Code Section 1036. If your transaction falls into one of these buckets specifically, you can now isolate the specific legal friction point that you want some assurance on and ask the IRS to rule only on that issue. So what's a significant issue? Because to utilize this program, you got to first prove to the IRS that your question actually constitutes such a significant issue. The revenue procedure provides a very precise three-part core definition. The issue must be a germane and specific issue of law. Germane means that the resolution of this issue is absolutely necessary to determine an element of the tax treatment of the overall transaction. Specific means it must be the narrowest possible articulation of the germane issue. You cannot ask broad, sweeping questions. Finally, there is one critical exclusion. The IRS will not issue a ruling if the conclusion is already essentially free from doubt. You cannot use this program to attain a comfort ruling on an issue that's already clearly addressed by the statute, regulation, or published guidance. You have to present a genuine legal ambiguity to get a ruling under this program. So how do we use this? What's required for our submissions? If you want to use this program, you've got to adhere to a modified submission requirement, which has been added to Section 6.03 of Revenue Procedure 2026-1, the annual private letter ruling procedure. Ruling requests must include a detailed narrative description that places a significant issue into the broader context of the entire transaction. Legal analysis is particularly demanding. You must analyze relevant law, cite the authorities most closely related to the issue, and crucially, explain exactly why these authorities do not resolve the issue to prove it's significant. You must also provide representations regarding the relevant tax consequences of the integrated transaction to the best of the taxpayer's knowledge. If you are requesting a ruling on a specific statutory subsection, for instance, let's say Section 355E, you must formally represent the transaction otherwise satisfies the remaining requirements of that overarching section. Finally, the IRS highly encourages practitioners to participate in pre-submission conferences with the Office of Chief Counsel Corporate before formally drafting and filing out the request. Okay. Now, limitations and cautions related to the program. While this program is a welcome return to targeted guidance, it's bound by some strict limitations. First, as I noted, the IRS will absolutely not issue comfort rulings. Your issue is clearly and adequately addressed by existing statute, regulation, or court decision, or authority published in the Internal Revenue Bulletin, the IRS will decline to rule. And so one of your first jobs is to make sure it isn't and explain why it isn't. What's missing in the available guidance. Second, post-transaction changes in circumstances generally will not be considered a valid basis for a significant issue ruling. Right? So you're not going to get it for that. Third, clients must understand that this targeted ruling offers no broad protection. The PLR will specifically contain a disclaimer stating that no opinion is expressed in the overall tax consequences of the integrated transaction. You're not asking for a ruling on that. You're not getting a ruling on that. That's how that one's going. You're not getting that protection. Furthermore, the IRS retains broad discretion. By submitting a request, you cannot box the IRS in. The service reserves the right to rule in any other part of the transaction, including ruling adversely on you if they deem it in the interest of sound tax administration. So you have to take that into account. There's a risk that while you might get the ruling on a thing you want, you're going to be told your whole transaction is now officially per the IRS. Sorry, won't accept that. And so go forward at your own risk, because we know about this one, and it looks like you might find an agent and a disallowance on your desk very quickly if you move on this. So, and of course, the standard no rule policies under Section 206-3, such as ruling on corporate business purpose under Section 355, still remain strictly off limits. And again, we have our nice little illustration here to help you if you are involved in this. The illustration, this case, you'll see it's on screen if you're watching the video. And again, you can download that and take a look at the slides if you aren't watching the video and listen to the audio. It outlines, eligible issues, the ruling types and the scope of the response you're going to get, and how you do the application process, summarized here on a nice little slide. Again, look at the details if you're doing this, but this is kind of the good broad overall view. Next, we're going to get to what the taxpayers call the Byers rule, right? And the Administrative Procedures Act, right? So this is the realm of IRS enforcement, qualified plans, and administrative law. The case of Daines versus United versus IRS. This is case number 24 CV 1057, a decision issued by the U.S. District Court for the Eastern District of Wisconsin on May the 4th, 2026. Now, this is a look at how taxpayers are aggressively attempting to use the Administrative Procedures Act to attack the procedural validity of IRS actions, including routine audit and enforcement actions. And also why that hammer doesn't necessarily work on every problem you've got. Right? Every problem is not a nail that can be solved by an APA claim or by yelling the words, basically, going ahead and yelling about Supreme Court precedent here. Loper Bright doesn't solve it either. We'll get here. Okay. So what's our background here? The facts revolve around an employee stock ownership plan and ESOP, right? Taxpayers established the Solid Ground Transportation, Inc. ESOP by utilizing a proprietary system, you can tell we're going here, aggressively marketed by an individual named Lex J. Byers to secure tax benefits. That's going to get us to the Byers rule as we get there, okay? There are subsequently loss examination in the methodologies of the Byers proprietary ESOP system. Following the audit, the IRS concluded the plan was not qualified in operation and revoked the trust exempt status under 501A for 2013 plan and subsequent years. Because this qualified trust earnings are now taxable, the IRS issued information document requests on Form 4564, demanding the taxpayers file Form 1041, U.S. income tax return for estates and trusts for all open years between 2018 and 2021. It's time to go pay up tax due on those earnings. The taxpayers' response was twofold. They challenged the subsequent disqualification to ESOP in the U.S. tax court, but they also initiated this separate lawsuit, District of Columbia, under the Administrative Procedures Act, taking aim at basically taking aim at the IDR directly, right? They're going after it, right? They're going for that. So information document requests, they're going after, trying to knock that down. Now, you might think they filed both in district court and the tax court. Well, that's going to come back and be a little interesting, too. We'll get here. And yeah, the district court took note of that situation. The taxpayers' challenge under the Administrative Procedures Act. The Administrative Procedures Act, if you're not aware of it, involves all federal agencies. And it deals with how they have to go about setting various regulations and rules. The taxpayers claim the IDR requiring the 1041 constituted by itself a new legislative rule, the Byers rule. So this was issuing an IDR was a rulemaking action, according to this. The taxpayers argued no IRC section specifically requires a 1041 from a qualified ESOP trust. And they sought to invalidate the IRS actions, in this case, they're saying, hey, it's not required, right? They said a statutory gap exists because no specific provision of IRC section 4975, 4979A, or any other section explicitly requires a Form 1041 for a qualified ESOP trust. The IRS demand constituted formal legislative rulemaking. They're saying they're overriding the law by imposing a requirement that's not there. Consequently, they request a court rule the IRS by the APA by bypassing mandatory notice of comment procedures and the Congressional Review Act. What was the court's thought on this? Okay, well, court says we have to deal with, is this rulemaking or is this adjudication? Right. Because that's going to be key. Rulemaking is governed by the APA. Adjudication is not. Under Title V, United States Code, Section 5514, a rule is defined as an agency statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. Conversely, an order, in this case, constitutes a final disposition by an agency in a matter other than rulemaking, which the court identified as routine adjudication. An audit. In the middle of an audit, the specific facts of the specific law, right? Citing Perez versus Mortgage Banker Association, a 2015 Supreme Court case, the court noted that legislative rules require public notice and comment and are defined in the negative against interpretive rules or policy statements. Relying on Hochter versus United States Department of Agriculture, a Seventh Circuit case from 1996, the court acknowledged that a legislative rule issued without proper notice and comment would be invalid. Ultimately, the court viewed the necessity for the IRS to interpret the law to arrive at an adjudicative audit decision as a standard application of law. This is not legislative rulemaking. There is no other way to enforce the law than by, when you've got an act in front of you, is by looking at the act, looking at the law, and then deciding if the act is in violation of the law. Does the law apply to this act? And that's different. Fundamentally, if you're viewing it that way, probably no federal law enforcement person could ever arrest anybody, right? You're doing a very specific rule. You need to go through APA and public notice and public comment before you can arrest me. Because nothing said this really, specific, unique set of circumstances somewhere in there was covered. It's like, no, we got to make that judgment call. We're not making that call for everybody right now. We're making it in your case and, in this situation. And that's just routine enforcement. Has nothing unusual here. Now, the court reject this idea of the Byers rule, right? And of course, why Byers was upset and called the Byers rule is obviously the IRS is essentially, going down his list of clients and, starting to disallow ESOPs left and right. So the court said your theory is resting on a flawed precedent. It was inconsistent with the plain language of the IDR. The IDR did not create a new rule that exempt ESOP trusts must follow Form 1041. Rather, concluded this trust was no longer exempt due to operational failures. A enforcement conclusion. Regarding a non-exempt entity, submit a 1041 as a conclusion that follows from finding a fact. If it's not exempt, it's got to file a trust return. Law requires trusts to file returns unless exempted, and this one lost an exemption from doing it, right? So it's direct application of tax law specific fact. That is, per the court, the very definition of routine adjudication. Taxpayers argue the IRS broad top-down enforcement against all clients using the Byers proprietary ESOP system constitutes rulemaking. The court, drawing on the Supreme Court decision from 1969, National Labor Relations Board versus Wyman, say the adjudicated matters frequently have broader effects and are serve as precedents. This does not transform them into legislative rules requiring notice and comment. Right. Finally, addressing the IRS's prior notice on the scheme, the court cited United States versus Bisceglia, I think it is, a U.S. Supreme Court decision 1975, reminding plaintiffs the IRS failure to audit a position in previous years does not stop the agency from enforcing the law later. Stop being a wonderful legal term, meaning, yeah, doesn't matter. You cannot say you can't enforce the law against me. You can't give me the speeding ticket going down a straight 10 from Phoenix to Tucson because I went down there earlier this year. I went the same speed down this stretch of road, and you didn't stop me then because you haven't stopped me in the past. You can't stop me now. Yeah, it doesn't work if you try to get out of a speeding ticket that way, and it generally doesn't work for this either. Okay. So, now, Judge Conway provided a memorable summary of the plaintiff's procedural maneuvering, noting they were trying to fit the square peg of routine administrative enforcement in the round hole of rulemaking under APA. Right? If the only tool you got's a hammer, every problem's a nail. The only tool that apparently the taxpayer come up in this case, trying to get rid of this, demand to file 1041s, was the APA. So even though it really didn't work, they tried to use it. Right? Court further analyzed jurisdictional limits set forth by the APA. Specifically, under Title V, United States Code Section 704, which permits judicial review only where there is no other adequate remedy in a court. Remember that tax court filing? Yeah. Court noted the taxpayer already possessed adequate remedy because their core substantive dispute over the ESOP's qualification and the assessed penalties was the subject of a pending tax court proceeding under, Internal Revenue Code Section 6213 and 7476. If they win that case, then the 1041s go back to being not required. That tax is irrelevant. Because the IDR and disqualification were adjudicative actions rather than legislative rulemaking, the court granted the IRS motion to dismiss the amended complaint with prejudice. Yeah, APA only works if you don't have any other opportunity to challenge. And they were challenging the very thing they're whining about in another court. Yeah, like I said, be careful. And one reason I kind of looked at this too is, a lot of times people, and it can be tax professionals, taxpayers, etc., they read a case like Loper Bright, and while it might apply to you, it doesn't mean automatically you win. Right? In fact, Loper Bright in particular, I remember talking with attorneys that go to trial on tax matters quite often, and they all agreed, Loper Bright is not going to do you any good in exam. Right? You got to get to court. You got to get a court to rule it. You're not getting a Loper Bright decision without a court already saying Loper Bright overturned a reg at the exam level or the appeals level, unless you simply get incompetent IRS employees that don't know they shouldn't do that, right? Because they should, right? That's bottom line. It's not their job, and even the most recent updates to the appeals regulations made it clear. Appeals is not in the business of claiming that what the chief counsel's office and Treasury put out as regulations, are invalid, unless a court's already ruled that way and the IRS has no appeals left. That's basically it. So again, looking at this issue, looking at the administrative code and all of those issues, we got these various other things involved. They were kind of various things in the case, so they're there. We'll let you kind of go with that. Okay. All this issue. Okay, next up, we're going to be looking at mail. Mail's fun. This is a stark warning regarding the evidentiary burdens the taxpayers face under the timely mailing, treated as timely filing rule. Gang, one of the most costly things your client can ever do is save the money from going and save the money and time from going into the post office and getting a certified mail little white receipt stamped by a U.S. Postal Service employee. And in Dunlap, that's going to come back to bite them, right? This is the case of Dunlap versus United States, case number 1:25-CV-02942, decided by the United States District Court for the Southern District of New York on May the 6th, 2026. This case highlights when federal court jurisdiction intersects with the strict tax deadlines and absolutely no room for error or close enough evidentiary records. There is one way and only one way, in the absence of a postmark on an envelope that the IRS has in their hands, because they're going to have that, because they end up with the end with what you mailed them. There's only one way for you to prove it was essentially timely mailed. Only one way. White receipt, not green card, white receipt. You can get the green card. Green card's irrelevant. White card stamped by a United States Postal Service employee. Now, green card maybe gives you an out if you lost the white receipt, only because the secondary route is proof of actual delivery, and postmark date. So, yeah, green card's interesting. You really need the white receipt to prove the postmark date anyway. So we get into that. But if you got enough records off the Postal Service website, you probably can prove all of that. You're just going to have a mess, right? Because you got to be able to prove that you actually took it in. And it was stamped by a U.S. Postal Service employee and a postmark was applied. That's your background. Okay. Let's talk about in this case. The case involves Mr. John T. Dunlap, right? He was serving as executor of the estate of Josephine A. Meyer. The estate has secured an extension to file his 2016 federal income tax return until October 15, 2017. The estate made a total tax payments of $448,067 in 2016, which Dunlap asserted included an overpayment of $60,483. Dunlap alleged he filed the Form 1040 requesting his refund via certified mail on October 3, 2017. However, please note that Mr. Dunlap never presented that little white receipt as evidence. Now, he may have thrown it away. I'm perfectly willing to believe that Mr. Dunlap mailed it certified mail. However, the courts will not be willing to assume that, because the regulations very clearly tell us that we need the white receipt, right? And the law very clearly tells us the IRS can establish rules on when certified mail will be treated as equivalent of registered. So we don't have a lot of maneuvering room here, right? The IRS issued a notice in July 2018 stating it never received the return. Dunlap claimed at that point he mailed a copy again in May of 2019. The IRS again says at trial they have no record of receiving that document. Finally, he filed successfully for a third time on October 27, 2022. Now, keep this in mind. The return was due. Extended return due date was October 15, 2017. The return did not get into the IRS's hands, where the IRS says they received it, until October 27, 2022. Remember, our statute here is 3 years. That's well outside statute. The IRS acknowledged the 2022 receipt, but again, denied the refund claim on the ground that it was not timely filed. A decision was upheld on appeal. So after exhausting administrative remedies, Dunlap filed suit under Title 28 United States Code, Section 1346A1, which grants district courts original jurisdiction over civil actions against the United States for the recovery of erroneously assessed internal revenue taxes. However, the court emphasized that to make a cognizable claim, get the right word in there, the taxpayer must strictly comply with the tax refund scheme and its jurisdictional time bars. The primary hurdle we discussed is Section 6511B2A, the look-back rule. This statute dictates the amount of a credit refund cannot exceed the portion of the tax paid for the immediately preceding the claim equal to 3 years plus the period of any filing extension, right? Applying this mathematical reality, the 2016 claim was extended to October 15, 2017. The estate needed to formally file its refund claim by October 15, 2020 to recover those tax payments. As noted, it was 2 years later. That's a problem. So this brings us to the evidentiary standards under Code Section 7502, Internal Revenue Code Section 7502, which governs the date of delivery for a mailed return. The general rule under 7502A1 allows the United States to postmark stamped on the cover of the mailing to be deemed date of delivery. Okay, that's great, but who has that? Well, if the letter got delivered, the return, the IRS has it. So then we got to hope they didn't lose it. But if it didn't get delivered because the Postal Service fouled up, then it's sitting who knows where. But the one thing I know we probably won't be true is we don't have it as a taxpayer. We don't have the envelope with the postmark. So the postmark doesn't help us very much, really, right? So the statute and Treasury regulations are unforgiving where the IRS claim non-receipt. Relying on Second Circuit precedent and Treasury Regulation 301-7502-1E2I, the court noted their exclusive means to establish prima facie evidence of delivery. You've got this. The IRS has to prove you didn't send them the return. In essence, which means if they're claiming they never got it, they got to prove they never got it or that you're lying. Those are not going to be easy things to prove. Let's be honest at that point. Okay. Unless a taxpayer can give direct proof of actual delivery. Yeah, I somehow get a copy of the letter from the IRS, the envelope and the postmark dates there. It's difficult to show actual delivery. There are some ways it's worked, but it's very difficult to meet all the requirements to show there was a valid postmark on there, the date. Remember, almost always the day of delivery, if you're going to mail it on April 15, it's going to get to the IRS after April 15. So what we have to really prove, not only that it got to the IRS, but it was mailed, right, on April 15, and more importantly, postmarked on April 15. Keep in mind, the law looks to the postmark date, not the date you mailed it. But they're the same, you might say. No. U.S. Postal Service, in the final rule adopted in December of last year, made it very clear. They are not the same. They will not necessarily be the same. They warn you as such. And they also tell us that actually hasn't been the case for a number of years. Right? You do this. So, if there's no proof of actual delivery, timely basis, which means, if I can show it actually got to them on April 14th, I'm good. But if it got to them April 17th, I still got to prove I got it mailed out by the 15th, right? So I either need the postmark envelope itself, again, I won't have that, or a properly issued postmark registered certified mailing receipt stamped by a U.S. Postal Service employee. Hint, don't go to the UPS store. Yes, they will sell you certified mail. But that receipt they give you doesn't count. What you just did was hired them to send somebody to the post office and get it in the mail and get a certified receipt. Now, these are people, lots of times maybe college students, etc., part-time, not generally going to be members of the tax bar or CPAs who do lots of tax or EAs that do tax. And they're not necessarily going to recognize that we want certified mail here primarily for proving the date of mailing. So if they're busy, they have a final tomorrow, they need to study for it, they can't do it, or they got left alone in the store. They had to be there till closing. Closing is after the post office closes. And they'll just take it tomorrow. Yeah, you just lost it. We've definitely had cases that have gone on things like that, so be aware of it, right? So, basic foundation. If you cannot produce that white receipt, that's the basic rule for everybody. There may be other ways to do it, but they're very difficult and rarely work. You need the white receipt. Bingo. The refund claim is legally considered filed on the exact date the IRS receives it. In this case, that was well after the due date. Not even close for it to be filed. So during litigation itself, the government attacked the court's subject matter jurisdiction under Rule Civil Procedure 12b-1. IRS introduced a declaration from an IRS attorney swearing the agency possessed no record of its return, the return's refund request prior to August 19, 2022. Now the burden goes to Dunlap to basically show the IRS is wrong. He needs statutory proof. Despite alleging his complaint he certified mail, he failed to produce the required postmark certified receipt. the white thing. By the way, this is something I do think a lot of tax professionals aren't good at. We tell the client to send it certified mail. We don't tell them what to keep. And more importantly, 9 times out of 10, if I'm talking to a tax pro, I'll hear them say certified mail with return receipt. That's not good enough. I don't care about the green card. The green card is not what we needed here. We needed the white receipt. They've got to keep that white receipt, because I'll also point out one other obvious fact. Let's assume the Postal Service loses that document entirely. Theoretically, we're exposed if they do that because, it still needs to be delivered to the IRS. But again, there's a presumption it got to the IRS. They got to prove it did. So that's going to be tough. Just like there's a presumption here that you didn't mail it on time. Right? You did, but you can't prove it. The court's not going to allow you to say you did. They're not going to let it in just for that. Same issue here. So, yeah, if the Postal Service loses that envelope, loses that package, that green card's never come back. And even if they don't lose it, they put it there, but then they lose the green card, that little card gets lost somehow, delivered to the wrong address, all kinds of weird things happening. We all have those days we go and meet our neighbors and exchange mail. Yeah, anything like that happens, yeah, that green card's not coming back to you. The white receipt is what you need because A, it's what the law says you need, and B, the only thing you got full control of is that. Bottom line. So now Dunlap attempted to rely on his pleading stage allegations, but the court reminded him even a sworn declaration attesting to mailing is legally insufficient. Just like the IRS swearing it really never made it here is legally insufficient. You got to prove it. And their statement's not enough to prove it, right? The statute absolutely required the physical postmarked receipt or envelope. Dunlap produced neither. Sad part is, he almost certainly had one, which was the receipt stamped by a postal employee. And I have little doubt he threw it away. And, if you were his advisor, you got to worry about, did you give him misleading instructions by saying, send it certified mail return receipt, and never said, oh, yeah, you got to keep the white receipt. That's issues, right? So returning to the case, the court pointed out in the tax refund suit, statutory time limit requirements actually constitutes terms of congressional waiver of sovereign immunity. They are strictly jurisdictional. Because Dunlap failed to provide the statutory evidence of timely mailing required by 7502, the court was legally bound to fix the filing date as August 19, 2022, date the IRS actually received the third copy of the return. That's almost 2 years past the deadline, dictated by code and the look-back rule. So the district court had no authority to hear the case. The government's motion to dismiss the action for lack of subject matter jurisdiction was granted. So the price of a missing postmark, or actually missing white slip. You got to understand the rule. And really importantly, you need to explain the rule to the client. Again, I'm going to tell you that if all your instructions say is file this certified mail return receipt, I'm not surprised if your client doesn't have what we need if the IRS said they never got it. We need the white receipt. Absolutely. I need to hammer that home to people. And then people say, well, the IRS will just claim it wasn't in the envelope. And my answer is they got to prove it wasn't. And they're most likely claiming this right now because the envelope had the postmark on it, most likely, which would prove the filing. It would prove the time. Again, their position was not to have an empty envelope with a postmark that came from you. Their claim is they never got anything. The burden's on the service to prove they never got the return. The burden's not on you to prove they did once you put this. Remember, IRS put forward their sworn statements that they had nothing. They'd done a search, right? And that's how it went. And I went back a little far here. Let's see, get back to where I was. So as you look at the slides, we jump forward a couple because I managed to brush the tracks back. Always bad when we do that. Now remember, the IRS does their proof. This is yours. This is okay. I see you. Now it's your turn. Prove you did it. Generally, once the white receipt is on the table, we're done with the argument about whether you filed it on time. I've had that be true about when the IRS has claimed it for clients, and we've got the white receipt. Everything goes away. And the courts will basically make everything go away. Finally, this came up late in the week, but I thought I'd cover it here this day. Our sixth and final development for the week, which is international trade and customs duties, and talking specifically about the limited nature of this ruling. A lot of people heard about this ruling, but I think a lot of people took a takeaway from it that it's as broad as what the Supreme Court did. It's not. You'd be very careful about this ruling. So, for CPAs and EAs advising clients engaged in international commerce, sudden shifts in trade policy have been massive tax and cash flow implications. The case here, State of Oregon et al. Versus United States and Burlap and Barrel Inc. versus United States. Slip opinion 26-47, decided by the United States Court of International Trade on May 7, 2026, deals with this issue. This is the response to the Supreme Court's basically throwing out of the initial set of tariffs. Okay. Now, this controversy begins on February 20, 2026, when the President issued Proclamation number 11012, imposing a sweeping temporary import surcharge of 10% ad valorem versus all articles imported into the United States. Again, remember, the Supreme Court had kicked out the old tariffs. The President, in this case, was going to replace them. The President invoked Section 122 of the Trade Act of 1974, codified at Title 19, United States Code, Section 2132, which grants the executive branch authority to impose surcharges to address fundamental international payments problems. To justify this, the proclamation cited modern economic metrics, specifically current account deficits, which reach 4% of the GDP, a broad trade deficit, and negative net international investment position. In response, a massive consolidated lawsuit was filed by two distinct groups of plaintiffs, 24 sovereign states and commercial importers, including Burlap and Barrel Inc. and Basic Fund Inc. We're going to find out the second group had much better luck than the first group. Because before reaching the merits, we had to determine standing, Article 3 standing, who had a right to bring this suit, right? The private commercial importers, Burlap and Barrel, Basic Fund, and the state of Washington successfully established standing because they had suffered a direct concrete injury. They directly imported goods and paid the new tariffs to the government through their customs brokers. Direct payment. However, the remaining 23 non-importer state plaintiffs argued they suffered indirect economic harm due to pass-through tariff surcharges from third-party vendors. Relying on the Supreme Court precedent in the case of Lujan versus Direct Defenders of Wildlife, the CIT ruled that these indirect pass-through harms were entirely too speculative to consider an injury in fact. As a result, the claims of those 23 states were dismissed. State claims gone, and importantly, broad claims gone. Right? Indirect harm claims were gone. So basically, according to the court, the only parties that had a right to bring this suit are those that directly paid, not those who may have, in reaction to the amounts going up, those tariffs being imposed, these importers may have raised prices down the line. That's an indirect effect. Court says indirect effects don't get you in the door here. So all the other states, bye-bye. Washington had directly paid the tax, so Washington's in, but in a very limited form. Right? So now we go to the scope of presidential support authority and substantive trade law, which is at the heart of the case. The Court of International Trade, which is the CIT, began by reiterating foundational constitutional principles. Article 1, Section 8 of the Constitution vests with Congress the exclusive power to lay and collect taxes and tariffs. Therefore, Section 122 of the Trade Act of 1974, which is codified at Title 19, United States Code, Section 2132, is not an open-ended grant of power. Only the Constitution can grant that. Right? The Constitution gave that to Congress. Congress can't just say, you take it. Well, let's do whatever you want, right? Power to tax, we get voted out of office to raise taxes, so we're just going to give it to a president. Because you know what? They can only run for re-election once, so the last 4 years of their term, they can raise taxes, and it won't matter. I'm not sure a lot of people like that theory. We'll put it that way, right? Rather, this section is a specifically constrained. The constraints are important. Delegation of that legislative authority to the executive branch. The core statutory requirement, section 122, dictates presidents may only invoke the surcharge authority where there are large and serious United States balance of payment deficits. The court looked deeply in the legislative history of the Trade Acts of 1974, determining that Congress deliberately used this term to refer to specific economic measurements, namely deficits in liquidity, official settlements, or the basic balance. Crucially, Congress explicitly distinguished balance of payment deficits from mere balance of trade surpluses within the same statute, indicating strict intent regarding the metrics required to trigger this executive power. It didn't mention balance of payment deficits as a trigger for this power. And to the court, that was like Sherlock Holmes' dog that didn't bark. Right? It's not there. And that suggests that you can't use that for this authority. Now, the government attempted to defend the tariffs by arguing the balance of payments deficit is a malleable phrase that must adapt to the facts of the day. Okay, first thing, that's not really how the courts, the current court, especially Supreme Court, has been liking defining things, right? Remember that the Supreme Court has been going much more heavily on what did these terms mean at the time Congress enacted this? What did the people that enacted it mean by this? Not, what term they use that totally changed meanings over, the next 20 years and now has a different meaning. But, like I said, when your only weapon's a hammer, every problem's a nail. So like the APA, we're going to try this hammer on this nail. Turns out it's not a nail. They point out the Bureau of Economic Analysis no longer even reports the exact components used to calculate the 1974 basic balance. That also seems like an interesting argument to me because, hey, wait, BEA is under the control of the executive branch. So if you just stop doing it, that enables you to do something different? Yeah. The court did not like this defense. Because balance of payment technically nets to zero in accounting principle, the court reasoned allowing presidents to arbitrarily pick and choose among sub-accounts, such as substituting a trade deficit or a current account deficit, would constitute an unconstitutional open-ended grant of authority. He always could find something, right? Because it nets to zero, right? Relying on the canon of constitutional avoidance and non-delegation doctrine, the court held the proclamation number 11012 entirely failed to identify statutory balance payment deficits. Therefore, substituting trade and current account deficits rendered the proclamation beyond the president's legal powers, ultra vires. Yeah. Because we're courts, we love Latin terms, right? Goes back to that, right? As a procedural side note, the state plaintiffs also attempted to invalidate the Customs and Borders Protection Obligation Guidance, right? Which was CSMS number 678-44987, under the Administrative Procedures Act. However, the court ruled they forfeited the secondary challenge by raising it too late in their reply briefs and failing to prove the guidance constituted final agency action. So maybe you should have mentioned the APA, unlike the one earlier, but you didn't. So, yeah. And this time, unlike the California Appeals Court, they said, yeah, you fouled up. You argued it wrong. Bad thing. Okay. So the remedies and the final injunction, this is important. Having concluded the proclamation was invalid and the tariffs were unauthorized by the law, the CIT turned to remedies. Now, a permanent injunction does not automatically follow a win on the merits. The court applied the four factors test from eBay versus Merck Exchange LLC, finding the importer plaintiffs, Burlap and Barrel, Basic Fund, State of Washington, demonstrated severe irreparable harm, including lost profits, price erosion, and loss of goodwill. The court balanced the equities, noting that the public interest strongly favors ensuring governmental bodies comply with the law, and thus granted summary judgment and a permanent injunction, but only to those parties, right? The CIT explicitly denied a universal injunction. Yeah, unless your client is Burlap and Barrel, Basic Fund, or the state of Washington, you got to go file your own suit, essentially. The relief and subsequent refunds are strictly limited only to litigating plaintiffs who establish standing. For the broader trained community, non-litigating taxpayers must likely seek their own relief or await the agency basically giving in on this ruling. So your client that paid them, right now there's likely nothing to see here unless the agency just gives up on this. Now they might, because again, the question is going to become, can we get this overturned? Because obviously if they don't move, if they just kind of sit there and say, we'll just let this one sit, there's just going to be a flood of these cases hitting CIT. So they really need to get overturned. Or they need to realize that they probably better go back and look for another way to do it. But until they do that, your clients are stuck for the moment. Okay? So this looks at proclamation, the video, the image here looks at proclamation 11012, the 2026 import surcharge and the CIT injunction. It looks at the mandate as law exists. By the way, on this image, that side of the image that shows how it exists, for right now, your client's impacted by that or just impacted by it. Like I say, because the people that get the judicial ruling on the right side are essentially three plaintiffs, right? And Washington only for the stuff they directly imported. Remember, indirect harm is thrown out. So you're not one of those three. That side is still effectively off limits to you, right? You're going to need to do something a little bit different. We'll have to see how far it goes. This concludes our review of this week's current federal tax developments. We're going up from in essence, the impact of speculative appraisals to conservation easements, to the strict evidentiary burdens of timely mailing rule, and the boundaries of state and federal taxing authorities. It's been an interesting week of developments and litigation. I said last week we had very little litigation. This week we have a whole bunch of it. Kind of interesting. As always, my email address, as always, current is on developments.com, is on this final slide. If you have a question, you can send a message there. I also do pay attention to the Connect sites for Arizona, New Jersey, Idaho, Illinois, Minnesota, and Washington. So if you have a question there, you can post to their Connect sites, and I'll take a look, see what I see. And if I think I might be able to answer, I may pop in and give you my thoughts on the topic. But otherwise, we will see you next week here as we look at whatever the heck comes out this week. Like I say, went for the week of virtually no cases to a week full of cases. Who knows what comes next? We'll keep our eyes open as we continue to keep our eye on current federal tax developments.